Hi everyone, Louisiana Succession Attorney Brad Scott here again. So what I want to talk to you about today is the validity of a last will and testament. This question gets asked of us all the time. People call in wanting to know if the will that their mom or dad made is valid. A whole host of reasons could be at issue. So under Louisiana law, there are a couple different types of wills that are valid. So let's talk about those first. One is the more traditional will that you'll see where somebody goes in front of a lawyer or a notary public and the will is typed up and executed in front of a couple of witnesses. That's referred to as a notarial will. Another type of will that's recognized in Louisiana is what's called an olographic will or a handwritten will. The criteria for it to be valid under Louisiana law to be a handwritten will is it has to be completely written out by the person making the will. It has to be dated by that person, and it has to be signed by them. If somebody else handwrites it and they sign it, it's not a valid will under Louisiana law. It has to be completely in their handwriting. So first thing we always address is whether the form of the will is correct, whether it is valid underneath an olographic form requirement or that notarial will that we talked about just before. If it's got the form correct, then the next question is did the person have what's called testamentary capacity? Meaning, did they understand what they were doing when they signed the will? And this is where a lot of litigation comes in. A lot of times people are signing wills right before they pass away, and it's questionable whether they understood what they were doing. Maybe they were on medication at the time. Maybe later in life they had some type of mental incapacity, whether it's Alzheimer's or dementia. And a lot of times that's what comes into play to say whether or not they knew what they were doing and they consented technically to the signing of this will. That's where a lot of challenges are made. The resolution of those issues is mostly dependent upon the medical evidence relating to the person who made the will and what the medical records and the doctors will say about their capacity. You really need strong medical records to prove a case up like that. The last issue as far as validity that we come across all the time is people will contest whether or not the actual signature was that of the person who made the will. In those situations, those are forgery cases. In those cases, you're getting handwriting experts involved in the case, and they're going to look at other handwriting samples of the person and try to compare it to that signature to see if they can distinguish whether or not that was them who signed it. In any event, there's a lot of questions surrounding the validity of the wills. One more that I always forget to talk about is an out-of-state will valid in Louisiana? And the answer is most of the time yes. If the will was drawn in accordance with the laws of another state, if it was valid at the time it was made, then Louisiana is going to recognize those wills as well. So if you have any more will questions, or if they're valid or not, feel free to reach out to us. We'll see if we can help you. If we can't, we'll try to point you in the direction of somebody who can. Until next time, take care. I hope this information helps.